Thank you for the opportunity to address you as the General Counsel of the Metal Service Center Institute. My topic today is antitrust compliance. I'll also be talking briefly about the chapter branding agreement and some other issues in the chapter leadership manual. At the outset, I just wanted to reaffirm MSCI's commitment to antitrust compliance and why we have that commitment. First, both in the MSCI membership guidelines at page 75 of your manual, as well as page 89 of the manual, at which a shortened version of our chapter antitrust guidelines are posted. And then turning to the next page, page 90, is the MSCI antitrust policy statements and guidelines. The reasons for our commitment to antitrust compliance are several. First of which, we obviously want to conduct our organization in compliance with U.S. law. Failure to do so can have dramatic consequences, one of which is being involved in litigation, either civilly or criminally, which would just by its nature incur significant litigation costs and expenses for the Institute. And the trade association landscape is littered with associations who saw their demise in large part because they did not anticipate or protect themselves against the antitrust laws. As importantly for this discussion today is our focus and attention on the chapters. Many of you have had some antitrust compliance training in the past, either at your current or former employers. Some of you have had not a great exposure to antitrust compliance. And that is yet another reason why we at the Institute want to make sure that our chapter leaders at least have a cursory understanding of the antitrust laws. And more importantly, in the event that any issues come to your attention going forward as a chapter leader that may involve antitrust, you are certainly directed and encouraged to consult either your chapter legal counsel and or me as General Counsel of the Institute. So, an overview of our antitrust laws would indicate that those laws are concerned both at the federal and state level with protecting free and open competition. There may be a myth out there that because we and or your chapters are nonprofit entities, that you are somehow immune from the antitrust laws, and that is not the case. In fact, many nonprofit institutions, as I've indicated before, have faced antitrust challenges. The antitrust laws themselves are concerned about the protection of competition, not individual competitors. While Major League Baseball may have the most prominent antitrust exemption or immunity, there are very few other activities that are immune from the antitrust laws. The enforcement of the antitrust laws is conducted by several agencies. On the federal level, we have the Antitrust Division of the U.S. Department of Justice with their primary office in Washington, D.C., and they have field offices around the country, as well as the Federal Trade Commission, also housed in Washington, D.C., with field offices around the country. Both of those agencies, for example, have field offices with significant staff in Chicago. In addition, there are state attorney generals who have empowered under state antitrust laws to investigate antitrust behavior. Our primary statute, which I wanted to talk about today, is the Sherman Act. That is a federal statute adopted in 1890 and has been virtually unchanged since then, whose primary purpose, as we will see in later slides, is to criminalize cartel-like behavior among competitors. In addition to criminal sanctions, again, which we'll discuss in more detail in later slides, the government also has the power to seek civil damages. Lastly, if that were not enough, that being government enforcement, both civilly and criminally, private parties, consumers, purchasers, competitors, for example, have the ability to also sue under these antitrust laws and not only seek damages, but attorney's fees and treble damages, meaning that if there is a jury verdict in the amount of $100 million, hypothetically, that amount is automatically tripled under the statute to $300 million. The purpose of that, as set forth by the drafters of the Sherman Act, was to disincentivize antitrust activity at the corporate level. So we have both criminal, civil sanctions by the government and private parties who may seek their own penalties. As I indicated, our primary statute is the Sherman Act, which is what we will talk about for the most part today. There's also something called the Clayton Antitrust Act. You may see references to that in the popular press about merger activity. That's beyond the scope of our presentation today. And lastly, in connection with the Federal Trade Commission Act, they have their own statute, which is much broader than the Sherman Act, which prohibits unfair methods of competition. And they leave it to the FTC, FTC law, and FTC attorneys and commissioners to determine what, if anything, constitutes an unfair method of competition. For our purposes today, we'll simply assume, though, that conduct illegal under the Sherman Act would also be illegal under the Federal Trade Commission Act, and vice versa. So the heart of the Sherman Act is Section 1, and the heart of Section 1 is the agreement, and the statute, as indicated in the first bullet point, condemns contracts, combinations, conspiracies in restraint of trade. The fundamental hallmark, as I say here in the slides, of Section 1 is the agreement. That being said, independent and unilateral action by a single competitor is not actionable under Section 1. The key to finding a Section 1 violation is to determine an agreement between or among two or more parties who are capable of conspiring. Typically, independent companies, like members of the MSCI, are not part of one economic enterprise and therefore are capable of conspiring. On the other hand, if there are chapter members who are economically affiliated with parent companies and subsidiaries, it would certainly be a question as to whether they constitute separate independent actors. But for purposes of our discussion today, we must assume that two or more parties, independent of each other, have entered into some sort of agreement. And as the slide indicates, the agreement can be formal, informal, written, not written, or even a wink and a nod. Any manifestation of conduct that indicates a conscious commitment to a common scheme is viewed as an agreement. Therefore, there does not need to be a writing to find an agreement, but there certainly needs to be sufficient intent and motivation by the parties to engage in common conduct to constitute an agreement. It's often raised, well, my local gas stations are independent of each other. A Mobil, a BP, a Shell, all may have the same gas price on a gallon of, or for our Canadian members, a liter of gasoline. Is that price fixing? No, because parallel conduct alone or parallel pricing alone is not indicative of an agreement. The problem would be if those independent operators of those three stations got together and agreed as to what their prices would be. The test for proving this type of conspiracy is laid out in a series of Supreme Court cases and indicated in our second bullet point under parallel conduct. That is, there must be evidence that tends to rule out the possibility that the defendants were acting independently. So simply, in short, parallel conduct, even on pricing, is not in and of itself illegal, but in the presence of certain plus factors, a court or clearly the government could reach a preliminary determination that there was something more than parallel conduct morphing toward an agreement. There are two tests, legal tests, to adjudge antitrust conduct under Section 1 of the Sherman Act, assuming there is an agreement between two or more parties to restrain trade that affect interstate commerce. The first test is called the per se test, which simply means that once the agreement is established, if the object or purpose of that agreement falls into the per se bucket, there's no further explanation of the conduct needed. In addition, there is no analysis of the market, effect on the market, or effect on competition needed. The Supreme Court has long held that certain types of agreements are so pernicious, or put another way, so bad, that they do not want to hear any explanation by the business people as to why or how or what effect the agreement had. We will get into some slides shortly on those types of agreements that fall into the per se bucket. Frankly, those are the types of agreements that we are most concerned about, and you should be too at the chapter level. The other test under the Section 1 of the Sherman Act is called the rule of reason, which does involve an economic analysis of the effects on the market of the agreement. Those types of agreements, for example, might be a vertical non-price agreement between a manufacturer and a distributor. Maybe the manufacturer limits the distributor's sales territory to Illinois. That is an agreement between two or more parties that restrains trade and affects interstate commerce. As a result, it facially violates Section 1 of the Sherman Act. However, the courts have long held that that type of agreement is not pernicious and therefore subject to the rule of reason and not the per se rule. We will not spend much time today on the rule of reason type cases. We will spend more time on what constitutes a per se violation of Section 1 of the Sherman Act. Again, here is the first slide of several, indicating for you the types of horizontal agreements that are typically found to be per se unlawful. Price fixing, agreements to limit production, bid rigging, market allocation of products, territories, or customers, or horizontal group boycott. I think it's important to note that certainly under the term of price fixing, simply agreeing to any term that impacts or affects price constitutes price fixing. Don't take this restriction literally that since I was not, quote, fixing prices, close quote, with my competitor, it's not per se illegal. Any horizontal agreement with competitors that impacts or affects price would be found in all probability to be per se illegal. Further detail on the types of agreements that have been found to be per se illegal under price fixing are set forth in this slide. As to the last bullet point, again, it is irrelevant whether the prices agreed on were too high, too low, reasonable, unreasonable, or what, if any, explanation people have for why they entered into the agreement. So you might say, well, we did enter into an agreement, but it had no substantial effect on the market or no substantial effect on competition. The government takes the position that that is irrelevant. The key is the agreement between or among two or more horizontal competitors to restrain trade in the form of a price fixing agreement. That is per se illegal. In addition, agreements to limit production or capacity are also viewed as per se illegal. Some of those examples are listed here. I would note that recently the Department of Justice has issued some pronouncements expanding the per se category to include what might be called no poach agreements between competitors. Let's say two competitors say, well, we are not going to try to steal each other's welders or line personnel. That's an agreement between two or more persons that restrains trade in interstate commerce. That would in all probability under the government's recent pronouncements be per se illegal. Again, there may be a legitimate business reason for that agreement, but the courts do not get to that legitimate business reason, as that type of agreement would fall into the per se bucket. For a long time, human resources type personnel and companies were relatively immune from the application of the antitrust laws. With this recent announcement by the Department of Justice, not only should operating personnel sales personnel be involved in discussions regarding antitrust compliance, but HR people as well. Another category of per se activity is bid rigging. Examples of the types of bid rigging that have been adjudicated by the courts and the government are set forth in this slide. Again, this is typically a matter for the Department of Justice Antitrust Division. If there is found to be some joint activity among competitors to rig bids, that would be viewed as per se illegal and criminal. Again, as to the last bullet point, it is irrelevant whether the agreement results in reasonable bids. The evil is in the fixing of the bids. Market allocation, also a per se category. Agreements among association members to divide or allocate customers' markets violates the antitrust laws and would be found to be per se illegal. Group boycotts, agreeing with competitors not to deal with third parties, would also be considered per se illegal. I indicated before there were criminal penalties, and this slide indicates some of those criminal penalties. Under the Sherman Act, fines can be assessed of upwards of $100 million per occurrence. So in the event, for example, that there were 4 separate price fixing indictments or charges levied against a company, that would be $400 million. With respect to conspiracy, especially on the civil side, there's a concept in the law called joint and several liability. That means if you have multiple parties engaging in this type of wrongdoing, the plaintiffs, and particularly the private plaintiffs, do not have to sue and find all the conspirators guilty. If there's a multi-party conspiracy and one conspirator is targeted in a lawsuit, that one conspirator would be responsible for the entire damage amount. As the second bullet point there indicates, there's no right of contribution from the one conspirator from the other conspirators. Again, this is consciously included in the statute and the governing case law to serve as a deterrent to people to engage in these types of conspiracies. Lastly, with respect to debarment, any individual company that does business with a federal or state government, even upon charging of a price-fixing conspiracy, may be debarred from further government work. With respect to criminal fines and sanctions against individuals, individual executives who are involved in price-fixing or per se violations can receive imprisonment up to 10 years and $1 million fines per charging incident. Again, if the idea is that the antitrust laws are dead or that the government is not enforcing these as rigorously as they have in the past, that is a myth that needs to be busted right here and now. The government, irrespective of the political administration in Washington, is very active and has been active and will continue to be active in this area of ferreting out conspiratorial conduct and charging not only companies but the individuals involved. As I indicated earlier, in addition to the criminal penalties and the government cases, on the private side, harmed consumers or purchasers who allegedly have paid overprices for fixed price products can sue and seek their attorney's fees and also treble damages. I briefly mentioned at the outset that the Federal Trade Commission also has some level of concurrent jurisdiction with these practices, and here is the slide that relates to how the FTC would view these types of arrangements. For our purposes, although the Department of Justice Antitrust Division in Washington is the typical architect of Section 1 cases, the FTC also gets involved. It should be noted, however, that the only agency to have criminal authority is the Antitrust Division of the Department of Justice, not the Federal Trade Commission. I wanted to alert you briefly at the end of our discussion to some other materials in the chapter leadership manual that should be helpful in your continuing and ongoing compliance with the antitrust laws. First, with respect to meetings, conferences involving your members and third parties, it's important to promote that there's an air or culture of antitrust compliance. As you see at MSCI national meetings, we have not only slides at the outset of our presentations and poster boards near the back of the conference rooms, but individual handouts on tables where members are sitting, reminding folks of our commitment to antitrust compliance and briefly laying out the do's and don'ts of the antitrust laws. This is a good practice. You should need to make your own decision on this, consult with chapter counsel, but it's certainly not atypical for chapters to have several copies of our antitrust guidelines prominently posted for attendees of meetings, conferences, or programs. In addition, as MSCI is, you need to be vigilant when you're bringing in an outside speaker to talk to your chapter, either your members and or other invited guests. Our event planning staff has other guidelines in the chapter leadership manual about finding the right speaker, but from the antitrust standpoint, finding the right speaker who will respect antitrust compliance is very important. As such, there are numerous topics which raise absolutely no red flags about antitrust. Other speakers, however, potentially could get into antitrust sensitive issues, which could also invoke liability for the chapter as well as individual members, and we certainly want to stay away from that. The other problem associated with that is in the form of questions and answers of a speaker. Those have to be moderated somehow to make sure that improper questions are not posed of a speaker and putting the speaker in an awkward position to the extent that they would have to respond that they're not able to get into that topic because of antitrust laws. It is much better to be proactive and prophylactic in those areas so as not to get involved in those types of situations. Put another way, finding the right speaker who will not create an environment in which those types of topics are being discussed is important. So for example, bringing in an industry analyst who attempts to talk about where prices are going is not something that should be happening at the chapter level. It is certainly not happening at the national level because it potentially raises antitrust issues. Again, getting your staff liaison from MSCI, your chapter counsel, and other people involved in the speaker selection process is good protocol to make sure you don't get into that type of situation. In the event you do have speakers who are potentially engaging in more business-related discussions, if they have slides, those slides should be previewed by counsel to make sure that those slides are accurate and not invoking any antitrust issues. In addition, as I alluded to before, allowing audience members to have a live microphone with such a speaker to ask any sort of question is also probably not good protocol. There needs to be some sort of filter, antitrust filter, between the audience and the speaker on these types of topics to make sure that improper topics are not asked in a question form. That may be as simple as having audience members submit questions on a 3x5 index card and having your chapter counsel look at those questions before they're presented to the speaker. In any event, engaging and having your chapter counsel involved in these types of programs is a very important component of antitrust compliance. Finally, with respect to antitrust guidelines for presenters, in your chapter leadership manual at page 100, there is a slide that outlines some of the issues I've been talking about here today. I think it's very good practice if you're getting a speaker who potentially could be talking about the current metals business issues and or future conditions forecasts, in addition to having your chapter counsel involved and in addition to having your MSCI staff liaison involved, making sure that that speaker has that handout. You may find that many speakers, when confronted with this issue, may realize that they do not want to put themselves in a situation of talking to a group of potential horizontal competitors about these issues. Anecdotally, just to make sure that you're not thinking that we're being Pollyannish or overly conservative about these issues, we have many, many members who applaud our efforts in this antitrust compliance arena, and in fact have stated that their organizations would not join or stay a member of MSCI unless we had such a strong commitment to antitrust. So it's part of our general platform. We adhere to it, and we abide by these measures on a daily basis. To bring this current, the Antitrust Division of the Department of Justice just announced within the last week of this presentation yet another pronouncement in the area of antitrust compliance, suggesting to U.S. businesses and those doing business in the U.S. that having an active and vibrant antitrust compliance program is essential. It is mandatory according to the Department of Justice. And again, it is not simply handing out a sheet and expecting people to adhere to it. It's actively enforcing that program and paying attention to the details. Those type of preventive steps can make sure that your activities are deemed antitrust compliant, and that is the goal of all of us. Thank you so much for reviewing this presentation today. And again, if you have any questions or comments or concerns about this topic, please direct them to me at MSCI. Thank you.